20 years ago, if I wanted to spy on my employer or my staff, I would need to invest a considerable amount of time and money and engage in a calculated level of deception to sneak in sophisticated equipment, set it up and operate it. But smartphones, Raspberry Pis and the record button on Microsoft Teams have meant that it is now possible for almost anyone to engage in a little bit of recreational espionage at work. The temptation is great. Oral evidence is notoriously unreliable, so why not preserve your position or jockey for forensic advantage by pressing the record button or installing a hidden camera? The purpose of this call is to go through the whys, the why nots, the whens and the hows. I'm going to start by going through a quick overview of the basics. Much of this may be familiar to you already, but these are the points that tend to come up on the initial phone call of, we've got a covert recording from our client or the other side, what do we do about it? Dan is then going to look at this from the perspective of dealing with employee covert recordings, and then I'm going to come back and deal with the question of employer covert recordings. So going through the basics, any covert recording is generally admissible even though it may be covert. Doherty is the main case on that. But there is an exception when it comes to private deliberations, disciplinary hearings and the like. Those are normally going to be excluded because there is a policy interest in keeping those private. But there is, of course, with any exception, an exception to the exception. If the recording is something that, for example, in a discrimination case is really the only evidence that will establish that discrimination took place or other unlawful conduct, then that may well be ruled admissible. In terms of the admissibility process itself, Vaughan is the key case to look at, and do keep an eye on the citation there. There are a rather large number of Vaughan and London Borough of Lewisham cases, which makes it no surprise that she took 39 hours of covert recordings of her employer. And what this case shows is the approach the ET will normally take, and it's the one to have in your toolbox for a case management hearing. Tribunals will interrogate this stuff. If you're going to rely on a large volume of covert recordings, they need to be transcribed, and you will need to persuade the tribunal that it is relevant. What happens when a recording is taken by an employee? Well, this can often be a disciplinary matter. Dan is going to be dealing with this in more detail, particularly the case of Phoenix House and Stockman. Of course, covert recordings may come up in the whistleblowing context. The two cases there are cited here, Bolton School and Evans, and the more recent Court of Appeal decision in Kong. Just because there has been a protected disclosure does not mean that all bets are off in terms of how the evidence was obtained. This can be severable, but if you are advising a client, do think quite carefully about whether they are being animated by the fact that the recording was covert or what the covert recording has revealed. In terms of a tribunal hearing or any other court hearing, it is of course a contempt of court to record proceedings without permission of the court, but there can be exceptions where reasonable adjustments are required. This sometimes happens, for example, in cases involving autism or ADHD, where a litigant in person will struggle to follow the evidence throughout the day and therefore needs a recording to be able to reflect on what has happened throughout the course of the hearing. There are the key cases on the slide. There is a practice direction as well about recordings of hearings, but that's more for getting a transcript in slow time. It is a very fact-specific case-by-case analysis. And then in terms of recordings, the other surprising feature is how often a smartphone worth over £1,000 meets with a watery end the moment a pre-action letter is fired off. A recent case in the EAT, Court and Sunmark Limited, is very much worth reading. If your employee or employer or any party has destroyed evidence or lied about it, striking out is a sanction available to a tribunal. And when you get the inevitable, my client took up a newfound interest in water skiing whilst taking a selfie, do interrogate the answer quite carefully, because quite often the voice recorder on an iPhone, for example, will automatically back up to the cloud. And so the destruction of the device very often isn't the destruction of the evidence. So that's the overview. I will now hand over to Dan to deal with employee covert recordings.
Thank you, Ben. Can I start with the straw poll? Hands up if you have been involved in a case which has concerned an employee who's carried out or made a covert recording. The vast majority of you. Of course, it's not a representative poll. We're very careful in ensuring we invite only the creme de la creme of employment solicitors to these seminars. Nonetheless, it does suggest that this is a practice that is widespread and about which it's important to get to grips with some of the key issues. Perhaps the first thing to say, at the risk of stating the obvious, is that employee covert recordings, as a generalisation, are a bad idea. Don't take my word for it, take that of His Honour Judge Richardson in the Phoenix House and Stockman case. It is good employment practice for an employee or an employer to say, if there is any intention to record a meeting, it will generally amount to misconduct not to do so. Generally, but not always. And David Richardson went on to say this: there was a time when an employee, or for that matter an employer, had to go to a great deal of trouble to record a meeting covertly. At that time, it would be straightforward to draw the conclusion that the recording had been undertaken to entrap or otherwise gain an unfair advantage. But in our judgment, times have changed. People carry with them a mobile phone which is capable of making a recording, and it is the work of a moment to switch it on. In our collective experience, and in the experience of most of the outstanding lawyers who attended the Littleton Employment Seminar, sorry, he didn't say that. In our collective experience, it is now not uncommon to find that an employee has recorded a meeting without saying so. Such a recording is not necessarily undertaken to, quote, entrap or gain a dishonest advantage. It may have been done to keep a record, to protect the employee from risk of being misrepresented when faced with an accusation or an investigation, or to enable the employee to obtain advice from the union or elsewhere. So that dictum encapsulates the likely battleground. The employer will have suspicions that the covert recording is an attempt to entrap or gain a dishonest advantage. The employee is likely to say that it was for a benign or innocent motive, such as ensuring that an accurate record of the relevant conversation or meeting was kept. Because, however, such recordings prima facie are likely to be, or at least might be, misconduct, they are of significant relevance to employers engaged in litigation against the employee. In particular, they provide the basis on which the employer can argue that whatever the underlying merits of a departure or dismissal, unfair dismissal or discriminatory dismissal, the employee shouldn't be awarded compensation, or any compensation should be reduced on the grounds that it would be just and equitable to do so, because they were guilty of the misconduct of carrying out the recording. And that was precisely the argument that was run by the employer in Phoenix House itself. That being the case, if you're acting for an employee, you need to have a wary eye on disclosure. Now, as you will all know, disclosure isn't the production of a document, that is inspection. Disclosure is stating whether or not a document exists or existed. So most recordings, surreptitious recordings by an employee, will be disclosable because they are likely to adversely affect the employee's case if they're not that category of recording that the employee himself or herself wants to rely on. That is because either the fact of the recording being made is potential misconduct, or the fact that it was made but didn't generate any adverse evidence to the employer might itself be helpful to the employer and something they would want to rely on. So on the face of it, if you're acting for an employee, come disclosure, you will be obliged to state that certain recordings have been made, whether or not they prove to be largely irrelevant and whether or not they still exist. And for that reason, knowing that the employer will prick up its ears when it learns of this fact and potentially argue that the employee was guilty of misconduct, amend their pleadings and argue that any compensation should be reduced or extinguished, the employee has an incentive to try and settle before that date for disclosure. So perhaps unusually, the employee may be pushing for a late date for disclosure. Normally, of course, it'll be the employer on whom the burden of disclosure principally falls, who will want to push off the date for disclosure. If you're acting for an employer, and there's any suggestion that the employee may have been making covert recordings, and sometimes you can see there are direct quotations in an originating application or in correspondence that suggests that that might be the case, I think it's well worth pressing the employee to confirm at an early stage whether or not that's the case, and if so, how many recordings and what circumstances they have been made. That is the scenario if the employee has left. What if they remain in employment? Well, on the face of it, for reasons discussed, the making of the recording may well be misconduct. So the employer will be inclined to investigate and potentially discipline the employee for that behaviour. There is, however, a problem with doing so, which is the restriction or prohibition on collateral use of disclosed documents, which arises not only in civil litigation but also in employment tribunal litigation. That restriction on collateral use is codified under the CPR, but in terms that on the authorities reflects the common law position. And what CPR 31.22 says is that a party to whom a document has been disclosed may use the document only for the purpose of the proceedings in which it is disclosed, except where, and then there are three exceptions. One, the document's been read to or by the court, or in parenthesis, or tribunal, or referred to at a hearing which has been held in public. Two, the court or tribunal gives permission. And three, the party who discloses the document and the person to whom the document belongs agree. So that is the prohibition. The courts take it extremely seriously, and the concept of use of a document is extremely broad. But you can make an application for permission to use documents. And this arose in a case in which I was involved last year. I was acting for the claimant, who was a very senior civil servant. She brought a claim while still in employment against her employer and her immediate boss, who was a relatively well-known public figure. During her employment, there had been a conversation between the boss and my client in which he had made some ill-advised comments about his unwillingness to continue to work with her. She was off sick, and she had a scheduled call with the head of HR. That was an important meeting. She wasn't particularly well at the time. She recorded it surreptitiously. She didn't tell the other party to the meeting that that's what she was doing. She said, and I had no reason to doubt this, that she did so simply so she had an accurate record of the meeting and so she could concentrate on the meeting whilst it was taking place. Come disclosure in the employment tribunal proceedings, the employer obviously discovered this recording and indicated that they wanted an investigative interview with her with the prospect of potential disciplinary proceedings. They said it was potential breach of a civil service code. They claimed it was breach of GDPR. They said that it had resulted in a serious breakdown in trust and confidence on the part of the head of HR. My client, who was very suspicious by this stage about their motives, refused, saying, "You're not permitted to have such a meeting because of the prohibition on collateral use." a point on which, as a matter of law, she was absolutely right. She said she provided her innocent explanation for the recording. She confirmed she had made no other recordings. And she said she would have a meeting if the employer would confirm in advance that whatever other action it took, it would not end up dismissing her. And slightly surprisingly, the employer refused to give that undertaking. Instead, it went off to the High Court to seek permission to use the document for the purposes I've just described, having an investigative meeting with a potential view to disciplinary action thereafter. Now, there was an initial issue about whether or not the High Court was the correct venue. Now, the leading case here is a case on the slide, IG Index and Cloety, that's how you pronounce it. It's clear from that authority that the High Court does have jurisdiction to grant permission, even though the proceedings are taking place in the Employment Tribunal. Whether the tribunal also has such jurisdiction is a more knotty issue. There are dicta in Cloety that suggest that it doesn't, but the reasoning that underpin those dicta is problematic. They are obiter, and they were made before the presidential guidance that's referred to on the slide, which states or implies that the tribunal can give permission for collateral use. And of course, if you're acting for an employee, there are significant advantages to that issue being litigated in the tribunal, not least there's no realistic prospect of you having to pay the costs of the application if you lose. In terms of the principles that are relevant to such an application, the key case is the Lacatania case. That's a commercial court case, but it sets out in considerable detail the relevant principles. I'm not going to attempt to summarise them now. The headline point is that breaching the restriction on collateral use is viewed very seriously by courts and tribunals. In Lacatania, there was a compelling case for collateral use, but the employer was having to seek retrospective permission. And although that retrospective permission was granted, and that was an opposed application, the High Court ordered indemnity costs against the employer to indicate its displeasure at the fact that the prohibition had been breached. So be aware of that issue and be aware of the risk of satellite litigation, which may be unwelcome to both parties, arising in those circumstances. I'm now going to hand back to Ben, and if you have any questions, ask him what a Raspberry Pi was, because I didn't follow that reference.
So moving over to the employer side, the risks if one engages in covert surveillance of employees is engagement with everyone's favourite piece of easy-to-navigate legislation, the European Convention on Human Rights, GDPR, and the common law. Obviously, any covert recording risks engaging with someone's rights to a private life. GDPR, it goes without saying, and it's clear from the ICO's own guidance that a covert recording is something that may well undermine the relationship of trust and confidence between employer and employee, and that obviously accords with common sense. So before we get into the practical side of how to navigate these, it's worth going through some of the underlying legal principles to see how they fuse together. So starting with Article 8, everyone has the right to a private life, but this is a qualified right with various exceptions. The most obvious ones that are likely to apply in these sorts of cases are the prevention of disorder or crime, for example, a stock theft, or the protection of rights and freedoms of others, for example, protecting another employee against their right to not be unlawfully harassed or discriminated against in the workplace. The way in which this is dealt with is a proportionality analysis. Those who practice in any sort of indirect discrimination cases will be familiar with how this exercise works, and there is guidance given from the Grand Chamber of the European Court of Human Rights in López Ribalda and Spain. López Ribalda was a case involving stock thefts in supermarkets by a gang of employees, and so alongside the normal overt and declared CCTV that you'd find in any supermarket. They installed hidden cameras above the tills so they could see who had their hand in them. This went up through the national courts all the way up to the Grand Chamber. And what the court ultimately held was that this was a justified interference in Article 8, and it set out a number of factors which I've put on this slide that one will have to consider when engaging in any exercise in covert surveillance, or indeed any surveillance. The first one, notification of employees, is obviously unlikely to apply. It is, of course, covert surveillance, but you might want to consider whether it's possible to notify a smaller subset of the workforce, for example, employee representatives or a local trade union. Second, obviously, the extent of the monitoring and the degree of intrusion. The more intrusive it is, the stronger the justification is going to need to be. And in terms of the monitoring itself, there is obviously going to be a difference between monitoring a generally public area, such as the till section of a supermarket, and a very private area, such as a changing room or a staff toilet. In terms of whether there are less intrusive methods available, this is, of course, the classic proportionality question. And in practical terms, what it emphasises is the importance of doing your analysis in advance. A data protection impact assessment that considers whether there are other less intrusive means in advance, engages with them and dismisses them, is going to be much more impressive to a judge than something that is put together after the fact, no matter how strongly reasoned it is. In terms of the consequences for the employees, this is always in practice going to be high, because if it's landing on your desk, it's likely to result in disciplinary proceedings or capability proceedings that may well result in the termination of employment or at least another career-limiting decision. And then you have to also consider safeguards. This might involve, like I say, the notification of staff or union representatives. It might require notification to the ICO, and it might require some form of complaints mechanism to challenge the way or the nature of the surveillance that is being done. There are further dicta from the ECHR on this matter, and I've summarised some of those at the bottom point. It's not enough to have the slightest suspicion of misappropriation or other wrongdoing. That is likely to be insufficient. What one had here instead was a reasonable suspicion that serious misconduct had been committed that was causing potentially significant losses. And in particular, on the facts of this case, it was a concerted action by a group of employees that justified a more intrusive level of surveillance. Moving from the international to the domestic arena, we have McGowan and Scottish Water, which confirms that proportionality, when it comes to the question of admissibility, is the key issue. If the surveillance is proportionate, it can be admitted. And in this case, there was surveillance of an employee's home to see if there was fabrication of timesheets, and that was permitted because it was a case of suspected fraud or dishonesty, so the seriousness was quite high on the scale, and other means of investigation had been ruled out by the employer, meaning that the tribunal was satisfied that there was no less intrusive way of investigating the issue. It's also worth looking for the slight wildcard city and county of Swansea and Gale, an employee who, whilst on his employer's time, decided that he was going to start playing tennis. And he wasn't working for a tennis company or sports club at the time. And what the court tribunal ruled there was that actually there was no interference with Article 8 at all, because he was in a public place. He was doing this on the employer's time, meaning that they were entitled to know where he was and what he was doing, and that there was no reasonable expectation of privacy whilst engaged in fraudulent activity. Now, I'd invite you to treat that case with some caution. It's obviously worth having in your arsenal, because it really is quite a strong statement to use against an employee who's challenging the admissibility of covert recordings. But bear in mind the more senior authority is, of course, Lopez Ribalda, which suggests it may, in fact, be a slightly more nuanced analysis that needs to take place. So those are the principles. How do we do it? Well, your key resources are going to be the ICO guidance and practices codes set out here. And those are really a synthesis of the legal principles and represent the ICO's position. You are unlikely to justify this sort of surveillance save in exceptional circumstances, such as to prevent or detect suspected criminal activity or gross misconduct. In terms of how you do it, you're going to need authorization from senior management, and you're going to have to consider the case for necessity. Like I say, you're going to be looking at criminal activity or serious misconduct. And much like if you go for an injunction without notice, you are going to have to consider whether informing your workforce is likely to defeat the purpose of the surveillance. You need to think about what sort of data you're going to capture. Audio recording is more intrusive than video recording. Will that reveal special category data, protected characteristics, trade union membership, political opinions? If so, you're going to have to justify your surveillance more robustly. And you are going to, of course, have to identify your lawful basis for processing. This is most likely going to be either to comply with a legal obligation or a substantial public interest with a basis in law, such as preventing or detecting unlawful acts. As with anything that engages the GDPR, a DPIA, data protection impact assessment, is going to be not just useful, the ICO views them as mandatory in these cases because they are likely to result in employees suffering financial loss if they are accused or caught up in wrongdoing. You will need to involve your data protection officer, and it is worth consulting the ICO in any such case. If you are going to conduct this sort of surveillance, then you need to consider your limits and safeguards carefully. Time frame, as short as possible, and not going to continue once the investigation is concluded. Location, what is the level of privacy? How reasonable is the expectation there? Again, shop front, tills, public places versus changing rooms and toilets. The ICO's view is that the latter are unlikely to be justifiable, and frankly, if you are looking at investigating in those sorts of areas, it might be that you need to consult the ICO and potentially even call in the police. If you are using third-party collectors, beware. Plenty of people offer their services for surveillance. Not all of them are conversant with their GDPR obligations, and it is not a very well-regulated area. It is going to be important that your contract only allows information collection in a manner compliant with GDPR obligations, and it is important that you only use the covert recording for the purpose it is intended to be taken. Any other information should be destroyed unless it reveals something no reasonable employer could reasonably be expected to ignore, and there is no other way to achieve that purpose. Obviously, there is a tension between that and your disclosure obligations, and those of us who are in this area will always be a bit reluctant to say, let's destroy evidence that's gathered. So it will be important, if it is being destroyed, to keep a clear, contemporaneous and justified record of what you have destroyed and why. And it is important to keep the investigation limited to those with a real need to know. You must set clear rules limiting the disclosure and access to this collected information. So the overarching themes then for employer covert surveillance are that this is limited to the most serious cases. You need to engage in a structured approach from the outset, including a data protection impact assessment, and the methods and the use of the data must be done in the most limited and focused way. Thank you.